Hi, this is Curt and welcome to another edition of Fire Law Roundup.
If you like strippers and you like fire engines, then the first story is one for you. This continuing saga will just never end. And let's just say the public wants to know why there were strippers in the fire engine and what happened, if any, for discipline. A judge has now ordered that the records, and I want to talk about which records because I'm not totally sure, but which records are they? The judge ordered that records be turned over about the investigation, and I think about the discipline, to the newspaper so that they can figure out what exactly has been done, what was investigated. The reason I asked,
let's orient everybody to what we're talking about. We're talking about
the
San Jose Fire Department, and this is the seemingly endless Pink Poodle strip club incident that happened last October, where a scantily clad woman was filmed exiting a San Jose engine company and walking into a strip club. And that video surfaced. The department started an investigation. That was very quiet thereafter, but the news media wanted some information. The city said, we handled it. The news media kept pressing, we want to know more about how did you handle it. And so the local newspaper was the San Jose Mercury News, filed a public records request or lawsuit, actually, for the investigative material. So, and my understanding is they were looking for the investigative records. So basically the, summary, basically the report. Any investigation should culminate in an investigative report. And my understanding is that's what they were looking for.
Yeah. And what's interesting is a couple-fold. One, don't forget, as I recall, the chief of the department or head administrator, somebody said heads will roll, they were very stern.
The mayor said that.
Right off the bat. And yet heads may roll, but we don't want to tell you what happened. But interestingly, in many states, I don't know about here, disciplinary records and their investigative material, each separately, may be, may not have to be disclosed in a freedom of information. Obviously not the case here. And it would be interesting to see, and I know we can look to see whether they tried to defend it based on these are disciplinary materials, because if they didn't, then you may know there was no discipline. And investigatory materials usually might not be, if there's no ongoing current discipline, may not in fact be exempt from freedom of information requests. But again, I don't know this specific state to be able to comment.
Every state's going to be different, and most states have some provision. Most states have between 20 and 30 delineated exceptions to public records. But one of the sort of general categories are personnel records, but they don't often get in more detail than personnel records. And you can make a good faith argument that an investigation or investigative report, particularly that culminates in discipline, is a personnel record. Of course it is. Okay. On the other hand, I don't think that's what they were, particularly a high profile incident like this. That's sort of when you understand why we have a public records law, that's exactly the type of thing that they want to shine some sunlight on, to make sure
they call
that
these the sunshine laws.
To make sure that the elected officials and then the appointed officials that work for the elected officials are actually managing problems properly. But be that as it may, California does have a firefighter Bill of Rights. That Bill of Rights does have some provisions in it about the release of information. So sometimes, and I've seen some other cases, I haven't seen a decision. I was looking for the decision in this one, so it'd be interesting. But there's a balancing when you have a firefighter Bill of Rights that give you protection, and you have a public records law that gives the public right, that the court actually has to do a balancing of interests. And there's another case out of California where it was a trial level, wasn't an appellate, but trial level decision where the court balanced in favor of releasing the information. So I don't know. And I don't usually study other types of cases like, for example, police officers or teachers or others. So there may be some cases out there involving other public employees that drive this. But one thing, Brad, as I was reading this, I don't know if you saw the quote. I put a quote in there from the mayor. Let me just read it. It says, "As someone who has been pushing for more and faster transparency on this matter, right? The judge's decision is good news. The public now will be able to see the key details of the investigation themselves, understand why significant discipline was imposed, yada, yada, yada." Here's my question. In order for a court to have jurisdiction, there has to be a controversy.
Yeah, I have an idea about this.
Right? When the news media files a lawsuit and the mayor goes, here you go, right? We support you having this information. There's no controversy.
No, but I saw that. What I suspect is he doesn't want to get sued by the people by releasing. Maybe there's a collective bargaining issue. So he hides behind, properly so, good advice, right? Yeah. Say, we oppose it, but we don't. You decide if it's exempt from, disclosure. And he says that, they probably said that to the court, like, you decide, we're not going to fight it, but we're not going to give it either until you tell us.
I'll take if I'm representing the union, I'm going to turn around and say, "No, wait a minute. What kind of phony baloney lawsuit is this?" Right. He rolled over on it. There's no controversy, right? And here's the thing, and this gets into a deep constitutional issue. If there is no controversy, the court lacks jurisdiction to hear the case.
Yeah. But I got to imagine that the mayor was just trying to protect himself and the city from the union.
I agree with you. I agree with you. But again, and we see this in other areas, by the way. We see this in other areas. We see it in consent decrees. Okay. We see it in other areas. And I question whether or not there legitimately is a controversy, because if somebody's suing, and the person you're suing is saying you're right, there is no controversy. Right. Without the controversy, there is no jurisdiction for the court.
They would have had to have denied it initially, right? So we made the request, we deny it. So they had to have denied it at first. And
this goes back to Marbury versus Madison, and what is the role of the courts in Article 3 and of the Constitution and all that. And so I always wonder whether or not in a situation like this, or even in a consent decree situation, whether or not there truly is a controversy. And in a case like this, whether or not someone could challenge the validity of this ruling by saying, you know what, the city really didn't have a controversy with this, therefore there is this ruling is invalid. So
normally the court would come out and say, listen, there is no controversy, and B, we don't give opinions, right? We don't give
That's right.
The courts don't give opinions. But again, I imagine that the city denied it. Or look, for all I know, and releasing records isn't executive decisions, not legislative. So the mayor is the chief executive officer. So if the mayor wanted it released, but maybe there's something in the city charter, we haven't read the papers.
I get you, but again, it's a little ironic where the mayor he's saying that
congratulations, we lost.
You know what I'm saying? And he's saying that he supported this. So, well, it sounds like the other side really didn't fight very hard on this.
Right.
So,
I agree.